Judge Glacier, I
Yes.
just wanted to check in and let you know that it does not appear either attorney have arrived yet.
Yep, I noticed that too. All right, well, we'll wait a few more, 5 more minutes, and maybe they
Okay.
forgot or what. Nick is available though, right?
Correct.
Nick is yeah, okay. So, all right, well, we'll give it 5 more minutes and I'm here. You can let me know.
Okay, sounds
I'll keep
good.
watching too. Thanks.
Judge Glacier, it looks like the attorneys have arrived and I can bring them and the court reporter in when you're ready.
Great, I'm ready. Thank you, Morgan.
Did I push the correct button?
I can hear Mr. Perlman. I can see Ms. Watsa. Ms. Watsa. Yeah.
Morning, Your Honor.
I think we're here. Madam Reporter, did you have a question?
I think Mr. Perlman's on mute.
Yeah, he is for now, but that's okay. I'll tell him when to unmute, but let me call the case. Good afternoon, everyone. Thank you for showing up. We're here on a summary disposition motion hearing in Gloria Jean Barnes versus Gretchen Whitmer and Joseph Gasper. This is Court of Claims number 21-193-MB. And I invited you here, counsel. I'll let you know why. I don't have argument in all of the summary disposition motions that come before the court in the Court of Claims. But I had a few questions for you in this case, and I felt that it would be easier for me to proceed to decide the issue that the defense has presented if I had some information. So I'm happy to let you argue if you want to, but I think the time might be better spent with me beginning by asking a few questions. And if those clarify the issues enough for the court, for me, I'll let you know. And if you want to provide additional argument, that's fine. And my questions really are primarily to Mr. Perlman. So let me start with you, Mr. Perlman. The defendants contend that the pending class action in federal court, which I will call, I believe you're calling Doe's 2. Is that correct? That Doe's 2 really encompasses potentially the claims that your client is making in this case. Do you agree with that? And if not, why not?
In part, but I believe that there are issues that are not addressed. And my client's issue in its totality is not specifically addressed in Doe's 2. I know that Doe's 2 pertains to the old, I think the difference is my client is trying to apply, they're trying to retroactively apply a statute that wasn't even, SORA wasn't in place when my client was convicted. And the law retroactively made her have to be on the registry for 25 years. She since served that time, and she's gone beyond that, and now we're here after she's already done everything she has to do, and then we're trying to effectively, another law, the new law is trying to require her to be on for even longer, which is, again, I know there are similar facts, but I think distinct, and just based on the timeline and the statutory and history of the various laws that have been enacted, and how it's really affected my client, and requiring her now to be a lifetime registrant. So just based on the mere timeline and how that correlates with the laws that have been enacted during that time period, I think it creates a different set of facts and a unique case that's not 100% consistent with the pending decision.
Okay. Well, I'm getting the sense, Mr. Perlman, that you don't really know what's involved in the Doe's 2, but maybe I'm incorrect about that, because as I read the complaint in Doe's 2, the plaintiffs are challenging the applicability of the third amendment of SORA, or the 2017 amendment of SORA, on precisely the same grounds that your client is challenging the application of SORA in the case that's before this court in the Court of Claims. I mean, that's my perception of the federal court complaint. But let me turn to Ms. Watsa for a minute. Ms. Watsa, let me ask you this. Are you involved in the federal case?
Yes, Your Honor. I am one of the defense counsels in Doe's 2. However, I do want to point out for the court, Doe's 2 resolved. There's a final order of judgment in August 2021. So I just wanted to make sure Your Honor was aware of that.
I wasn't.
There's
And
a
I
Doe's
think
3, if I'm not mistaken. Is that correct?
Yes, Doe's 3 was just recently filed, as was a motion for class certification. The defendants in that case also agreed to stipulate to class certification, but that has not yet been entered by the court.
Okay, well, it would have been helpful to have that resolution of Doe's 2. I'm not sure, I didn't see it filed. I could have overlooked it. It could be in the record somewhere and I overlooked it, but here's where the court is going at this moment in time. I can't decide this case, especially on res judicata grounds, until I know what the federal court decided. I mean, res judicata applies to decisions that have been made, and I don't know what decision has been made. And
Your
I don't know
Honor,
what's pending. Go ahead, Ms. Watson.
I apologize. I wanted to correct the record. Exhibit B to our motion is the Doe's 2 amended final judgment.
Okay,
So that lays out in detail what the court ordered, as well as we also filed as an exhibit. I'm just looking for it. Apologies. We also filed as an exhibit the Doe's 2 class certification, Exhibit A.
the Doe's 2 or the Doe's 3, did you say?
Doe's 2 class certification.
I did see that.
Yes.
What is Doe's 3?
Doe's 3, it was recently filed. It's currently in the very beginning of litigation. There are numerous counts in that case. If you give me one moment, Your Honor, I will pull up the case number in
Well,
the district.
I want you to file it with this court anyway, with the Court of
Okay.
Claims, a copy of the complaint. But let me ask you this, will Ms. Barnes be a potential plaintiff in Doe's 3 as well?
Yes.
Okay. All right. So I presume your position is, but correct me again if I'm wrong, that perhaps she will be entitled to relief as part of Doe's 3, but it's impossible to say at this point.
If plaintiffs are successful in Doe's 3 and if the class is certified, then yes, she would be entitled to relief, assuming those two things happen. But again, she is a member of the Doe's 2 class. And just as the Eastern District noted, Judge Cleland, who was also oversaw the Doe's 2 class action, that Ms. Barnes is a member of the Doe's 2 class, and respectfully disagreeing with Brother Counsel, she is not claiming anything different. Her claim for relief in this case, as well as the 2019 Eastern District case that she filed, was not seeking any alternative relief. And Your Honors, if I may, plaintiff's counsel also abandoned his request for declaratory and injunctive relief in his response to my motion, and is therefore only seeking a writ of mandamus. But again, as we indicated in our briefs, there's no clear legal right to be removed from the registry in this case, and there's no clear legal duty to remove her from the registry for a number of reasons, including that Doe's 1 does not support her request, and Doe's 2 not only does not support her request, but also the SORA was amended during the pendency of Doe's 2, and the amended final judgment in Doe's 2 specifically states that pre-2011 offenders still must comply with their duty to register under the new SORA. So for a multitude of reasons, plaintiff is not entitled to the relief she seeks here.
And Doe's 3 challenges the new SORA?
Yes, Your Honor.
Okay, so Ms. Watson, could you please file with the court the complaint in, or whatever you have, whatever pleadings are available to you in Doe's 3, please file those with the court. The court is going to stay this case pending the outcome of Doe's 3, because it makes no sense for this court to duplicate the work of a federal judge. I presume it's also assigned to the same judge?
That's one of the issues being litigated, Your Honor.
Okay, well, the federal courts have had this in their hand for a long time now. I really don't see any reason for this court to step in, given that there's a potential class action that's going to be certified covering the exact same, or at least one of the same issues that Ms. Barnes raises. So, I think it would be a senseless duplication of this court's effort to decide what I presume is a constitutional question involving the application of ex post facto and all of these other cases that the federal courts have in hand. Mr. Perlman, any objection to that approach?
No, that makes sense, Judge. So essentially staying the case until those 3 is resolved.
Or there's some decision in those 3 that would enable this court to then decide whether you're entitled to mandamus. I mean, it doesn't necessarily have to be resolved, but there could be some ruling that comes from those 3 that gives this court the green light to decide a mandamus question.
That's fair. That makes sense.
But I can't imagine right now what that would be. But I also really think it's not in anyone's interest, particularly your clients, for this court to decide an issue that is in the hands of the federal court anyway.
I understand, Judge. Thank you.
Ms. Watson, are you okay with filing things with the court?
Yes, Your Honor. I can also point out that the filings are made public by the ACLU who filed those 3. If you'd prefer, I can refer you to that website, or I can finish.
No, I would prefer you file it with the court. We never know in these cases, in these Court of Claims cases, how long any of us are going to be on the Court of Claims.
Okay.
We keep hoping that the Court of Claims is going to go away from the Court of Appeals. So just to keep our record pure and unadulterated by anything else, I would really appreciate it if you wouldn't mind keeping the Court of Claims informed of what's going on in the federal court. You'd be doing us a big favor.
Absolutely, Your Honor. I'm happy to do that.
Okay, great.
Thank you.
Thank you both. Any questions from either of you? I think we've probably covered it, but happy to listen.
No, I have no questions, except when is the next court date for those 3, if you're aware, Ms. Waza?
I'm not aware of the next court date offhand. Like I said, it's still in the preliminary stages. There's been, I believe, defendants' responses to a motion for preliminary injunction are due April 11th, but I have to double check that date.
Okay, so I'll continue to track that. I have no further questions. Thank you.
Ms. Watson, anything you want to add?
Nothing further, Your Honor. Thank you.
Great. Well, thank you both for coming. I appreciate both of your candor. And as I said, the court will enter an order keeping this case sort of on hold pending developments in the federal litigation.
Very good. Thank you.
Thanks a lot. And I don't need a copy of this. I don't know if either of you do, but I don't need a copy of the transcript.
No, I don't need a copy.
Okay. Thank you very much.
Thank
Thanks,
you.
everybody.
Bye-bye.
Bye-bye.